We are live and recording. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations, within and for the Commonwealth, draw near and give your attention, and ye shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning. Welcome to the Appeals Court. I am Justice Meade. With me this morning for your cases, or your case, are Justices Wolohojian and Massing. Each side will be allowed 15 minutes of argument. You needn't use all of your time. We have read everything. We do not entertain rebuttal. If you'll see us periodically looking off screen, it's because, at least in my case, my notes are on a different computer screen, so we haven't actually lost interest in what you're saying. With that, we'll call our first case, and that's Commonwealth versus KEARSE Jr. Mr. Meade.
May it please the court, my name is Attorney James Methy. I represent James KEARSE in this appeal. The first issue in my brief was that the evidence was insufficient to prove that my client constructively possessed the gun that was found on the center console. There has to be other incriminating evidence besides the fact that my client is just in the car. So we will look at what the other incriminating evidence is, and I would argue there really isn't any. He's a passenger in the car. He's not the driver. He didn't own the car. The weapon was not in plain view. In fact, not in plain view, but the testimony was that even if you open the center console, there was a tray on top of the console, and there was paperwork on top of the gun underneath the tray. So that even if you opened the center console, you couldn't see the gun. There were no personal items of my client inside of the car. He made no damaging statements. He made no further movements. And I would argue the fact that he had his left elbow on the center console, I would argue was just an innocuous act and doesn't show that he had knowledge that the gun was there.
May I ask a couple questions about the facts? Sorry. It's my understanding that the center console without your client's arm on it couldn't close. It popped open without the weight of the arm on it. Is that correct?
There was testimony to that effect, but what I would point out is that there was actually conflicting testimony by the Commonwealth's own witnesses on that, because even though Officer Callahan testified to that, Officer Williamson testified that when he went to get the gun out of the console, he took the gun into evidence that there was nothing wrong with the console, that he opened and closed the console, that it wasn't broken or it wasn't ajar. So I would argue
but Callahan testified that it was, and we have to look at the evidence in the light most favorable to the Commonwealth, and contradictions in the evidence are to be resolved by the jury.
Well, I understand. I would just argue that because it's the Commonwealth's own witnesses who differ on this fact, that it hasn't really been proven even in the light most favorable to the Commonwealth.
Callahan says that the console would open and that it was ajar, and in the light most favorable to the Commonwealth, your client was holding the console down with his elbow in a rather awkward manner to prevent it from opening in front of the police officers.
That was the testimony. I have to agree with that.
There's also the evasive conduct prior to them even approaching.
Well, I was going to get into that a little bit further on the motion to suppress, but I would argue that, again, that there was, in the light most favorable to the Commonwealth, it didn't show my client had knowledge of the location of the weapon and the ability and intent to exercise control.
Attorney Methy, can you help me a little bit on the ownership of the car? You probably haven't seen the co-defendant's brief, but there's some conflicting suggestion in his brief that your client owned the car or perhaps controlled the corporation that owned the car. Can you help me with that?
I didn't see anything about that.
Okay.
The testimony during the trial was it was owned by a corporation, which was actually, I think, in Maine, and it was a corporation from Maine, and at the gun was purchased in Maine. So I don't think
The gun, I remember the gun was purchased out of state, but the car, I thought the gun was purchased from an individual or what had been
Right.
purchased by an individual.
Right,
But the
right.
car was in the name of a corporation.
right.
Was there any explanation as to what the corporation was? I take it wasn't a rental. It wasn't like Hertz or Avis or some rental car corporation.
No, it wasn't. I can't remember the exact name of the company right at the moment, but
And there was no evidence
I-
that would attach the corporation to either of the co-defendants?
I don't believe so. I'm positive that there was no evidence at trial about that.
Okay, thank you.
You wanted to reserve on the evasive action. But I think it's evidence of consciousness of guilt. So why isn't that something that we can consider in the sufficiency?
Well, I don't think the driver is really evasive. I think that it was at night. The police were an unmarked cruiser. They merely drove by Mr. Hishe's car, driving the car. And then Mr. Hishe driving the car pulled into the parking lot. And then the evidence was they sat there for 10 minutes or so. And then they got out of the car for 10 minutes, came back and then left the parking lot. So I don't really see how that's evasive driving.
Wasn't there evidence that they kind of parked out of view behind a snowbank?
Well, I know there was some mention of that there was a snowbank there.
I mean, so how many? So you can't be just mere presence, but you need some plus factors. But how many plus factors do you need?
Well, I would argue there's no plus factors. You need at least one or more than, you need at least one, that's for sure. The second issue in my brief was that the motion to suppress should have been allowed, even assuming the stop of the car was justified based on a traffic violation of going through the red light. Police still needed reasonable belief that the safety of the officers was in danger or the safety of the public was in danger for the exit order. And they also needed reasonable suspicion that either Mr. Hishe or my client was armed and dangerous in order to do the frisk and then to search the car. The judge found a number of factors justified the exit order. I believe there were 7 factors she found. And I would argue that her findings of fact are clearly erroneous and these conclusions are wrong. Again, one of them was the evasive driving. I would argue, again, I don't really see how you can call that evasive driving.
Yeah, but the problem, Mr. Methy, the problem with that is that I forget whether it was O'Brien or Callahan testified that they were operating the car in an evasive manner, and the judge expressly credits that.
Well, again, I'm arguing that her conclusions based on on the facts are incorrect.
And did you say the stop was not justified?
No, I didn't say that. I said,
okay,
assuming the stop was justified. I said.
All right. Well, they ran a red light and they weren't wearing seatbelts, so there's 2 reasons to stop them.
Yes, that's true.
They also had a criminal history of involving firearms violations, both of them, and that your client had a gang affiliation, and that one of his fellow gang members had been shot, and that there was a lot of shootings in this area, I think.
Yeah, there was testimony about that. I understand that, but my argument would be that alone, that the records alone, and that some of the information alone was not enough for the exit order and the search.
Well, we're not isolating just the records. It's we, as the motion judge did, looks at all of the circumstances put together and whether it reasonably justified a concern for their safety and to justify the exit order. Right,
I understand. If I could just get into some of these other factors or conclusions the judge made, which I think are erroneous, as to the other factors for the exit order. There's testimony about Mr. Hishe being nervous, which I would argue was really not credible. He testified, there was testimony about his heart beating through his clothing or something like that. And on cross-examination, it was brought out that he had put that in a number of, that officer had put that in a number of reports before. Apparently the police disbelieved that my client was, Mr. Hishe, were visiting somebody there, which they never really investigated. They asked about the first name. They didn't know the first name, but they didn't investigate that any further.
Neither of them. The judge found that they weren't being truthful about visiting the cousin because no one knew her first name.
Right. Well, but then it turned out that I know the judge didn't have this in evidence in the motion, but during the trial, a person testified that yes, Mr. Hishe, I knew Mr. Hishe, and he came often to visit. So I know the motion judge doesn't have that, but
yeah, that's not before us on the motion to suppress.
Right. And another fact that a judge found was a justification is that Hishe not having his license on his person, but they checked his license before they ordered him out and found he had a valid license. So I don't really see that as a factor justifying the exit order and the search.
No, it was when they searched and they realized that he did have a license. They also were able to determine that he had convictions for firearms offenses. So it wasn't license; it was record for.
There was evidence about that. I think the conviction was like 12 years before that, but anyway, I understand. The third issue of my brief was that Officer O'Brien's testimony that, quote, I knew Mr. KEARSE, end quote, was prejudicial to my client, deprived him of a fair trial. This issue was the subject of a motion limine prior to trial. The judge says I'll rule on it later when it comes up. And then the trial counsel from Mr. KEARSE raised it again prior to that, and the judge allowed the motion. In other words, the police officers were not supposed to say anything about knowing Mr. KEARSE.
And when counsel objected, the judge sustained it and struck the evidence, and later explained to the jury that they weren't to consider evidence that had been struck.
I understand that, but you know, the damage already been done at that point. And my, you know, I see this all the time in these trials where police officers interject these things when there's really no reason for it. In fact, the question, I know it's on cross-examination, but the question was just, quote, you asked Mr. KEARSE for his full name and he provided that information to you without a problem, end quote. It called for a yes or no answer. And he had just given a yes answer to the previous question about Mr. Hishe's information.
The jury was told not to consider it, and we have to presume they followed the instructions.
Well, I would argue that, you know, the defense didn't open the door with that question. This completely uncalled for answer, and it was prejudicial to my client, because the jury is going to assume that if Officer O'Brien knew my client, then he knew him because of prior criminal involvement, not for any other reason.
May I ask you about this? I understand what you're arguing. I hear you. But where the evidence has been struck by the judge, and the judge tells the jury not to consider it, have we ever, or the SJC ever, found that the fact that a witness said something alone was enough to reverse a conviction? In other words, because right, the remedy the judge had, the judge exercised. The judge excluded the evidence, struck it from the record, told the jury not to consider it. So, what else could the judge have done at that point?
I don't think there's any, he could have allowed the mistrial. That's what he could have done. There was a request for a mistrial, which he denied.
Okay, have we ever held that in a similar circumstance that the denial of a mistrial was an abuse of discretion?
I don't have an answer for you on that. I'm not sure. But as I said before, I think I see this all the time in these trials, and there's no ramifications for this kind of intentional prejudice that's caused by a police officer's testimony.
How would we know? I mean, was a request made for the judge to find or determine whether this was an intentional violation of a restriction on the testimony?
No, there
So,
was,
I mean, we couldn't make that finding here in the first instance. So,
yeah,
how would we presume that?
just by the context, I think. And this is a close case on the facts. I mean, as I argue, and I think even for Mr. HISHE, it's a close case on the facts. And I think something like this makes a difference, and it could have prejudiced the jury against my client. The mistrial should have been allowed. There's no further questions. I ask the court to reverse the judgment. Thank you.
Seeing none, thank you very much, Mr. Meade. Mr. Shorey.
Good morning, Your Honors, and may it please the court, Benjamin Shorey on behalf of the Commonwealth, asking you to affirm the defendant's conviction. Addressing the sufficiency of the evidence first, I would just point to the significance of this holding down the center console, where the testimony was pretty substantial on this point, that the defendant was actively putting pressure on the center console and put his arm was awkwardly placed on it with his left hand on the driver's seat, with the seat fully reclined. Once he gets out of the vehicle, they immediately see that the center console has popped open. He remains in that position for the entire traffic stop until he's removed from the vehicle, covering that center console. Of course, once the console is seen ajar after he's taken out, there's additional context of an explanation for why he might be sitting that way, and additional evidence that he's actively covering up the gun in the center console. To clarify the issue of supposed conflicting testimony on whether this was the center console was in fact ajar, I don't think it's directly relevant with viewing the evidence in the light most favorable to the Commonwealth. But I think the record is clear that the Detective Williams took photos after having removed the tray that was on top of the firearm, and that was the explanation for why the center console was no longer popped open.
So in other words, the reason why it was ajar was because the gun was in there and it couldn't fully close.
Because the gun was in there with a tray on top of the gun. And when he was taking pictures of the gun inside, the tray had been removed. And you can actually see the tray sitting on the passenger seat in the photographs. Just to
is that the how many plus factors do you need? You've got the leaning. What other plus factors would you point to?
Well, I don't think you really need anything more than that. I think that's a very substantial one, and I think it's enough here. But I do think you have the evasiveness in combination with the defendant's inability to give the name of the cousin. That testimony came in at the trial as well as the motion to suppress, that both defendants were unable to provide the first name of the cousin. And Mr. KEARSE, really the evasiveness, I think, primarily goes to Mr. HISHE as the driver, of course, but Mr. KEARSE is present for all of that as well, and then actually leaves the car with Mr. HISHE after sitting in the car for 5 minutes, and then returns to the car 5 minutes later. So he's part of leaving this car behind the snowbank, leaving it running with the lights out. So he really does join in this evasiveness as well. So I do think there are multiple plus factors there. I would point to the both defendants raised the issue of some other person, the issue of this corporation owning the vehicle, and other people at some other time may have left the gun there. And just point to the fact that the gun was not only loaded, but there was a bullet in the chamber, which the court recently, in addressing specifically the sufficiency of the evidence on whether a defendant knew a firearm was loaded, has found that very significant, in that the gun apparently was intended for immediate use. So I think that further links the gun specifically to the occupants of the car at that time.
Is there a recent case? You said there's a recent case that talks about that?
Well, I think Grayson and Resende both kind of address that issue, and Mitchell as well. All three of those specifically on the sufficiency of the evidence for loaded firearm. But I think Resende and Grayson in particular kind of turn on that question of whether there was that plus factor suggesting the gun was intended for immediate use, as opposed to something that had perhaps just been given to the defendant. So, so I do think the nature of the firearm being loaded is significant here as well.
Did the jury hear about the context of the gang activity, or was that just for the motion to suppress?
That was just the motion to suppress. As to just to clarify on the suppression evidence, I think there were just additional evidence. I mean, substantially overlapping with the trial evidence, but of course you have the additional firearm evidence there. It was very substantial and multifaceted. So both defendants having prior firearms records, but then 3 prior shootings, 2 within a week of this incident in that area, and then 1 several weeks prior in which a fellow gang member of Mr. KEARSE was actually murdered. So I think that evidence adds substantially to the suppression analysis. To clarify to the extent I can on the issue of this corporation, my recollection is just that the evidence was just that it was owned by a corporation, and then I believe there are pictures admitted in evidence that showed a commercial license plate. I don't think the evidence was any more than that.
There was no evidence that would suggest that either co-defendant had a connection to that corporation.
I believe that's correct, Your Honor.
Okay.
To address sorry, I jumped back to the sufficient the evidence a bit there, but to one more issue on the suppression issue, defense counsel has addressed the nervousness and again, maybe some question about the reliability of Officer O'Brien's testimony. Point first, of course, the fact that the judge did credit this testimony, but also to the fact that Officer Callahan also observed this nervousness and testified that this was the most, in his 6 years as a police officer, this was the most nervous he had ever seen anyone during a traffic stop. As to the third issue raised by the defendant, the testimony by Officer Callahan that he knew Mr. KEARSE, I think it's dispositive of the issue that it was struck from the record, but to address the suggestion that it was because some type of intentional impropriety, this was not really a non-responsive answer. I mean, it wasn't, the question could have been answered yes, no, but the question was, can you tell us whether Mr. KEARSE provided his license when you asked for it? And the answer was that he already knew Mr. KEARSE. So it wasn't just volunteered out of the blue. Of course, it shouldn't have come in and it was struck, but to clarify the intentionality claim there. If there are no further questions, I would rest on my brief.
Seeing none, I thank you both.
We are live and recording.
Thank you. Welcome to the appeals court. The next case is 2020 P933 Commonwealth versus HISHE. We've heard the companion case already, Mr. Weber. Each side gets 15 minutes. You needn't use all of your time, and we do not entertain rebuttal. So with that, why don't you go right ahead?
Thank you. Philip Weber, representing Mr. HISHE. And in the rest of this case, I'll begin with the sufficiency of the evidence. I was watching previous arguments, so I know that there were some questions in regards to the visibility of the gun when Mr. KEARSE's elbow wasn't on the center console. In regards to that specific element of things, I would point out in the transcript from the suppression hearing on page 125, it does state that the picture that was taken before the weapon had been secured by the detectives. So that is stated in there. So the gun is still in there at that moment. And even in regards to how potentially visible it may have been, also referring to the transcript from the suppression hearing, page 27 in particular, there was testimony that when Mr. KEARSE's elbow was removed, that essentially it opened a couple of inches, is what the testimony was. So a couple of inches, because when you look at the picture itself, obviously when the center console is closed, the gun is not visible at all. And you can see the picture, it's, I believe, very questionable if a couple of inches would be enough to make the gun visible.
I hear you. I guess I'm wondering, what I hear you are making is some kind of plain view argument, that the gun was not in plain view. Why does that matter?
Well, in regards to the sufficiency of the evidence, it's not so much I understand why it sounds like a plain view argument, but it's not so much a plain view issue. It goes more to Mr. Hishe's knowledge of the gun. Because if the gun was sitting where everyone can see it, then he would have seen it as well and known it was there.
Sure, that would be a different case and arguably a stronger case. But here, at least to me, it seems that the fact that the co-defendant had his arm on the center console in a way where it could be inferred that the purpose of holding it that way was to keep down the lid of the center console so that what was inside would be kept out of view. Why isn't that enough?
Well, I would argue that it's not the only reason. I mean, putting your elbow on a center console is a very common action when a person.
Sure, but there are lots of things that can give rise to competing inferences, and we have that all the time. And you know as well as I know that when we're up on appeal, we have to take those competing inferences in favor of the Commonwealth. So here, I think that the most favorable inference for the Commonwealth is that the KEARSE's arm was on the console for the purpose of keeping the console cover down to obscure from view the gun that was within.
Well, even if we do take it in that regard, it would show at most that Mr. KEARSE was trying to obscure something. That doesn't mean that Mr. Hishe knows that there's a gun in there. We can take from that at most that maybe he thought, oh, Mr. KEARSE might be trying to hide something, and that doesn't mean he knows specifically that a gun is in there. It might just mean, oh, he doesn't want me to know that something is in there. And a person trying to hide something doesn't automatically give rise to knowledge that there is indeed a gun in this car. There are so many different possibilities, and that's assuming he knew that he was hiding something. And that elbow on the console would probably be the only thing that could be pointed to that would show that Mr. Hishe had any kind of knowledge that something was trying to be hidden.
Well,
what about the evasive driving?
Well, for that, I would just point out that a Black man being stopped by a police officer at night and being nervous about it, I don't think that shows that.
We're talking about sufficiency, right?
Yes, although I think that the issue of his evasive does go to both sufficiency and the suppression issue. It does relate to both, but at this moment, yes, in regards to sufficiency, him being nervous about police officers, because while his nervousness could be debated, it certainly for this purpose, for the light most favorable to the Commonwealth, it's reasonable to say that he would have been nervous. Him being nervous around a police officer, a young Black man being stopped by a police officer in Boston, and therefore being nervous about it.
But it was more than his nervous conduct. It was his evasive conduct, how he drove the car, how he hid it behind a snowbank, how they turned the lights off, how they briefly got out of the car and re-entered the car, and then later how they lied about visiting the cousin, didn't even know her name.
Well, in regards to the supposed evasive driving, it's not clear that Mr. Hishe knew that a police officer was following him, because this is an unmarked vehicle.
Do you think anyone in the city of Boston doesn't recognize an unmarked police car?
I think that I've seen Crown Victorias are not only driven by a police officer, because that's what the Commonwealth points out to as it being obviously a police officer. Crown Victorias are not a car that has to be driven only by a police officer.
We let jurors use their common sense in the jury room, right?
Yes, Your Honor. But even if he knew it was a police officer, all that would show is he doesn't want to get pulled over by a police officer. And again, I don't mean
But that doesn't view the evidence in the light most favorable to the Commonwealth. In the light most favorable to the Commonwealth, he's avoiding any interaction with the police, and then later lies to them.
And avoiding interactions with the police, not wanting to deal with police officers, even when looking at the light most favorable to the Commonwealth, I believe it's too much of a jump to say he's nervous around cops and doesn't want to interact with them. That means he knows there's a gun.
We have to look at everything together. We're not going to isolate each piece of evidence.
Certainly. Well, but outside his evasive, his supposed behavior really is just about the only real thing to point to that would show knowledge of the supposed knowledge of this gun. I mean, there's not really the only thing common point to is he didn't want to be around the cops, and the other guy who was in the car with him has his elbow on the console. In terms of knowledge,
he can see him holding the console down with his elbow, right?
He could see an elbow on the console. The difference between someone casually having their elbow on the console and pushing down on the console with all their might, especially when Mr. Hishe was driving. So I think it's quite a reasonable inference that while a person's driving, they're not staring at the center console. They're not putting all of their attention into what the other person in the car is doing with their elbow. At least they shouldn't be if they want to be a good driver and pay attention to the road. I think that is even giving the light most favorable to the Commonwealth. He's not staring at his elbow. He might look over and see, oh, he's got his elbow on the center console. And again, that is one of the most common actions a person does, having an elbow on a center console. That really, I would say that just in general, an elbow on the center console means nothing, even if it's there constantly.
Well, it doesn't mean nothing, because we actually have testimony that it means something. And that something is that he was holding it down to keep it from popping open, which is what happened when he took his elbow off it.
And then we took his elbow off it maybe a couple of inches, which unfortunately there are no pictures of what it looked like with a couple of inches ajar. So we don't actually know what it looked like in regards to it. But what we do know is that the police officers didn't even testify. They didn't even say that this couple of inches, they didn't say it was a couple inches and then the gun is immediately visible. They say that it was a couple of inches and then that they, looking for the exact, the center console was ajar and he looked in there and found a firearm. So the police officer even says, once the elbow's removed, their next move is to look in the center console and find a gun. They don't even say it's ajar and then suddenly the gun is there and we can all see it.
Did they say when the gunner is removed, the console closed properly?
Well, I don't recall the exact testimony in regards to that. All I know is what the picture looks like. And that picture is stated, the testimony does state that picture is when the gun is still in there. It does appear that the tray has been removed, because I do see the tray in that picture on the passenger side, as the Commonwealth had stated before. So, but with the gun in the console, it does appear that the console still closes entirely. If that's what the console looks when it's a couple inches ajar, then clearly the gun cannot be seen. If that picture shows what it looks like with the gun inside, and if that's what it's ajar. What
inference can be drawn from the fact that the gun was fully loaded and ready to be fired?
Well, the question I think really more relevantly is, did Mr. Hishe know anything about that? Because again, in regards to this constructive possession, because clearly this is a constructive possession issue, there's nothing.
He has a gun that's, well, let's give it a whirl at my question. he's driving a car that has a gun that's fully loaded, ready to be fired in the center console. What inference can be drawn from that?
The inference that I would draw from that is that Mr. KEARSE wants to have, potentially Mr. KEARSE would want to have a gun that's ready to be fired. I don't think that says
and
anything.
Perhaps he's working in concert with Mr. HISHE.
If I believe that would be speculation at this point, as there was no.
Well, would it be speculation if we included again the evasive conduct and then the lying to the police about where they were?
Again, I believe that would just show that Mr. HISHE, it shows that Mr. HISHE doesn't want to deal with the police, that he's nervous around that. Certainly not.
Or Mr. Weber, or in the light most favorable to the Commonwealth, it shows that he is covering up for the crime that the two of them are committing. Consciousness of guilt.
I do believe that there's a difference between giving a light most favorable to the Commonwealth and giving assumptions towards the Commonwealth. However, even in regards to constructive possession, as your honors are aware, I don't believe there is enough to show he had knowledge. But even if there were enough, even if Mr. HISHE had knowledge of the gun, knowledge alone would not be enough. He would have to show the ability and intent. Now, certainly not going to argue ability. Center consoles in view is in reach of a driver, but the intent, there was nothing to show, again, that he would have an intention to use the gun, even if he had knowledge. Now, if he had knowledge, and again, I don't believe there's enough for that, but if he had knowledge, that could be, as your honor was saying, why he wouldn't want the police to get more involved in things. But again, there was nothing that showed that he would have an intention to use the gun. None of his possession.
Mr. Weber, on page 37 of your brief, can you pull that up for me, please?
Yes, one moment while I pull that up. Okay, yes, your honor.
In the first full paragraph, about 2, 4, 6 lines down, I have a sentence that says, indeed, Mr. KEARSE, as the owner of the vehicle, had equal, if not more, access to the contents of the vehicle. And that sentence has caused me more confusion.
Yes, KEARSE had equal, if not more, access to the contents of the vehicle.
So
the owner part that bothers Judge Wolohojian.
Yeah.
Is there any evidence that he's the owner?
That Mr. HISHE was the owner?
No, that KEARSE is.
KEARSE was the owner of the car.
I believe, I thought that it had been discussed as Mr. KEARSE being the owner of the vehicle. If I was wrong about that, I would certainly apologize. Really, my intention more than anything else in that regard was that Mr. HISHE, Mr. HISHE was clearly not the owner. I apologize. In 2 minutes, obviously, I don't have time to sufficiently go through the record to confirm, but I had believed that Mr. KEARSE had been the owner and that previously a corporation had been involved, as I know that had been discussed as well. It was my understanding that Mr. KEARSE was at the time, the current owner of the vehicle.
But it also has to be before the jury too.
I believe that it was. If I'm incorrect about that, then I would certainly apologize. It's certainly not impossible that I would have been incorrect about that. My real focus was more so that Mr. HISHE wasn't. That was really what I thought was much more, at least for Mr. HISHE's purpose, more relevant, that it wasn't his car, that he was just the guy driving at that time. As that really was, I'm pointing to the corporation was simply just to show the number of people who had access to that car, that this is not some car that Mr. HISHE and KEARSE had been the only 2 people who had ever been in it. It was really more so just talking about that the gun had numerous places to come from, but most importantly, that Mr. HISHE wasn't the owner of the car. And as a person just driving the car who wasn't the owner, there indeed is a case law which I cite to talking about how simply driving a car doesn't mean you're responsible for all the contents of the car. There has to be more. And for the reasons stated in my brief, I would argue that there is not enough here to show that Mr. HISHE either was aware of the gun or had any intent to control it. And unless there are any questions, I would rest on my written brief.
Seeing none, thank you.
Thank you.
Mr. Dory.
Good morning again, Your Honors. May it please the court, Benjamin Shorey for the Commonwealth, asking you to affirm the defendant's conviction. If I can, let me just clarify a couple of points from the record here that came up. As to the whether the car could be recognized as a police cruiser, as to the sufficiency of the evidence at trial, there was express testimony that it was easily recognizable as a police car and that it had low profile lights and an antenna on the roof. The suppression testimony was a little less clear, but I think it was still more than sufficient for the judge to find that it was recognizable as a police car. At both suppression and trial, there was actually video of just before from a traffic pole just before the stop that came in that shows the car, so the judge and the jury could view that. I mean, you can certainly see, it's not very clear video, but you can certainly see it's a Ford Explorer with the large police grill on the front. There was also testimony at the suppression hearing because the judge appeared to be trying to clarify this very issue, and so after the counselors questioned the witness, the judge did, and the officer testified to it. The car being specifically the anti-crime car, the purpose of which is to be in the area to deter crime, suggests the fact that it was recognizable as a police car is inherent in that. And then it was equipped to actually conduct this traffic stop, so we do know it has lights in that regard from the suppression hearing. And then I do think it's you can put some weight on the fact that the way the driver started driving after the police car was behind him. So I think there's evidence of that, and you put full weight on the evasive driving that Mr. Hishe engaged in, specifically as it relates to the sufficiency of the evidence at trial.
I understand all of the evidence going towards knowledge and of the gun and ability to control it. Where I'm struggling is on the sufficiency of the evidence of the intent to control. Can you help me with that?
I think the knowledge and intent, the evidence of those things is in the case I've read, it's substantially overlapping, and especially in the case where a driver he is the driver of the car, and sure. If we assume for your purpose of your question that he knew the firearm was there, I think all the evidence of knowledge would go directly to intent. If you know about contraband that makes you so nervous before police that you're demonstrating that nervousness and you're intentionally trying to avoid police, that you wouldn't have that gun in your car just casually, or be kind of okay with your passenger bringing it along. He has
what is your best case for the propositions you just forwarded? That just knowing that you have a gun in the car and you're driving the car is going to be, and the fact that you don't want the police to find out that you're driving a car with a gun in it is enough to prove beyond a reasonable doubt your intent to control that gun. I mean, he's clearly controlling it in the sense that while he's driving the car, it's moving around with the car. But if he's driving a car down Main Street, then the gun is also moving down Main Street. But I don't think we've said that. I don't think that's the substitute for the intent. If you intend to drive the car, you're intending to also control the gun. I don't think we've said that.
To the extent I said that's what you said, I certainly didn't intend that.
I'm not suggesting that.
I agree. I don't think there's a clear case that says knowledge equals intent. I'm just pointing more generally to the cases on constructive possession, where I think that you look at what the evidence of knowledge is substantially overlapping with intent, and I don't know if I've seen very rarely.
But we do keep them as three different things. There's knowledge, there's ability, and there's intent. Now, it may be that the same evidence is enough to satisfy all three, but the same evidence may not be enough to satisfy all three. So what I'm asking is if you wouldn't mind to specifically focus on the intent piece, because I have a hard time, I have no difficulty seeing knowledge and ability. Those seem clear to me, but the aspect of intent, this driver's intent to control the gun. And in this regard, I'll tell you, frankly, the Commonwealth places a lot of weight on the meaning of the elbow, right? And the elbow, though, somehow seems to also give rise to a countervailing inference, which is that it's the passenger who's intending to control the gun.
Well, I do think you can put, I mean, I do think in this particular case, there's substantial overlap in the factors, and I think that's reasonable in the circumstances of this case. But I would note the defendant as driver, if of course, if someone has a gun in their waistband, that's stronger evidence, and it's on their person, and they clearly very strong inference that they intend to exercise control of that vehicle. But if they have it in the center console next to them in the car that they're driving, while intentionally trying to avoid police, I think that gets pretty close to having it on one's person, right? And I'm not saying this is an actual possession versus constructive possession, but he's actively exercising control over this gun if he has knowledge that it's in the center console and he's driving the car in attempts to avoid police with it being there. So I do think the evidence is really substantial on both knowledge and.
So it's the evasiveness. What is the evidence that, in your mind, it is the evidence of intent?
Well,
the driver's intent to control the gun.
Sure. So he's intentionally. I mean, if he has knowledge, right? If we assume that for a moment, I mean, he's intentionally is exercising control, and that he's driving around with this gun right next to him in the center console, right? And so I think that is the actual exercise of control over the gun. And
that's what I asked you. So you're saying driving a car with the gun, the intent to drive the car with the gun is the proxy for the intent to control the gun that's in the car.
I think, and then of course the added fact that the gun was ready to be used, right, with a bullet in the chamber, would suggest that both parties intended for it to be used. So,
And on these facts, your closest case is what?
Your Honor, I haven't found a case, direct. I mean, there are a lot of specific facts to this case. So nothing like that would really be closely analogous. But I do think Commonwealth versus Craps, 84 Mass Appellate Court 442 addresses this fact that it's the driver of the car, and we really just need a hair more where there's contraband. In that case, it was drug evidence, but where there's drug evidence as the driver of the car, that's not enough by itself, but we just need a bit more. And then Santana, 95 Mass Appellate Court 265, does specifically address the factor of the person who's controlling the car as being a factor in whether they're controlling that contraband. Again, not suggesting it's enough, but it's a relevant factor. So that's the evidence I would have, or the cases I would have on that front. If I could go on to just address a couple of the points in terms of the center console being ajar, just to be clear, in response to Attorney Weber's argument, I've never argued that meant when it was ajar, the gun was visible inside at that point. And then as to Attorney Weber's suggestion that evidence of knowledge may have just been knowledge of some other contraband in the car, not specifically of a firearm as it relates to the sufficiency and to the sufficiency. I think at the point that, while that may be true up until they find the firearm, once they open that center console and find that the contraband is in fact a firearm, I think any significance on the fact that he may not have, I think we lose any argument that he may not have known what item was in there.
Am I correct that the jury acquitted this defendant on the loaded firearm charge?
Correct. That's correct.
And also on the possession of ammunition charge?
Correct. So he was convicted only of count 1. If there are no further questions, I would rest on my brief.
Seeing none, thank you. Thank you both.
We are live and on the record.
Welcome to the appeals court. I'm Justice Meade. With me this morning are Justices Wolohojian and Massing will be your panel. With that, I'll call the next case. 2020 P926, FRATUS versus Harwich Board of Selectmen. Mr. Watt.
Good morning, Your Honors. May it please the court. I am Alexander Watt, and I represent the appellant Robert D. FRATUS, Jr. Briefly, by way of background, Mr. FRATUS owns and resides at property on a road called Seth Whitefield Road in Harwich, also sometimes known as Hawk's Nest. You can see at Record Appendix page 75 a little map which may orient the court a little bit. Seth Whitefield Road is a road that runs north and south. It runs from a road called Queen Anne Road up to Hawk's Nest State Park. Intersecting with that and running easterly from Hawk's Nest Road is Round Cove Road, which is a town road.
Mr. Watt, I'm going to interrupt. I'm going to
Yes.
start to interrupt you. We've read the briefs. I want to ask you a particular question about this.
Certainly.
The town makes it what I thought was a pretty interesting argument that Seth Whitefield Road is actually still a county road and not a town road, and that because Barnstable County was not one of the counties that was abolished. Do you agree with that?
I accept the representation by the town to that effect. Certainly not in the record, but irrespective of that, I accept it as it's a county road.
Did you only sue the Harwich?
Well, Harwich is the entity, the selectmen are who Mr. FRATUS petitioned for the repair of both roads. Now the town
Is the responsibility for the maintenance of a county road the town's or the county? And was there any request by Mr. FRATUS to the county?
There was no request made of the county, and with respect to that, I mean, if you look at the statutory framework, Chapter 82.
Mr. Watt, so in answer to my question, the follow-up by Justice Wolohojian, having looked at the caption more closely now, it's the town of Harwich and the individual board of selectmen are named, who are not county officials. And if the upkeep of the roads in Barnstable County is an issue for the county commissioners, it seems you've sued the wrong people.
The town is responsible for the maintenance of both county roads and town roads within their jurisdiction. That's set forth in Chapter 84, Section 1, which refers to the repairs of highways and townways. Highways are somewhat of a term of art that refer to roads that fall under Chapter 82. That would be the county roads. And town roads are obviously what are created by the town.
Is Seth Whitefield Road a county road?
It is a county road.
And you're saying that Chapter 82 still makes that the town's responsibility?
Chapter 84, Section 1 sets forth that they have to repair town roads and highways.
And where in 84 or 82 or elsewhere is there a private right of action?
So with respect, and this goes to the standing question, with respect to county roads, there's a specific provision in Chapter 82, and that's Section 17, that allows the selectmen to exercise original jurisdiction for the layout, repair of highways. So that gives the selectmen the authority.
Wait, which is that? Did you say, sorry, chapter 82, section 21?
Section 17.
I thought that, oh, I see. Okay, that refers to highways.
But
So I think if I could just finish.
The authority that makes them responsible for the upkeep, but it seems that the mechanism that we have here is that if there's a problem, if the road's not kept up to standard and somebody gets injured, they can sue. And that's the incentive for the towns to keep things in order so they don't get sued and have to pay for damages. But it doesn't seem like any citizen can say you have to repair the road.
Well, to be sure, chapter 84, section 15 confers that specific private right of action for people who have suffered personal bodily injury as a result of some defect in the road,
or damage to property. But there's no, that's not the situation we're in here, correct?
Correct.
I mean, your client has not sustained personal bodily injury or damage to his property.
Correct, Your Honor, and nor do we claim under section 15.
Right.
What we claim is that under section 1, there is a class of people for whom the town has the obligation to keep roads in repair for the safe and convenient travel of travelers, including their vehicles.
But it also says that a city or town shall submit a letter of request for such repair and for approval by the State Department of Highways. It doesn't say that individual abutters or landowners or travelers has a way of precipitating repair of a county road. At least I didn't see that.
It does not say, it does not give a specific right to petition for the repair by abutters or anyone traveling.
Right. So if it does, though, give a right to the town to seek, well, it says that it's mandatory that a town shall submit a request to make a repair to a county road. Doesn't that affirmative statement somehow contradict the idea that you're relying on, which is that a private person can precipitate a repair to a county road?
I don't think that necessarily follows. There may be a separate obligation for the town to petition the commission, but in the first instance, whether the town should effect the repair, I think can come at the request of, in this case, Mr. Fratus, who's a traveler, as well as an abutter on the road.
Well, so, I mean, you would agree that this chapter 84, section 1 only requires the town to keep the road in a reasonably safe and convenient for travelers condition, correct?
I do, Your Honor, yes.
Okay, so one thing I looked for that I could not find in the record was any record of what the town's decision was or the basis for it. In response to Mr. Fratus's request. I don't see any records from whether it was the town meeting, the selectmen. I don't see anything. I may have missed it. Can you point me to it in the record?
Yes, Your Honor, I don't believe that there was ever a written decision. It was just oral at the hearing, and there is nothing in the record.
Is there a transcript? Was a transcript made at the hearing? How are we to know what the reasons were that the town gave?
there is nothing in the record regarding that.
Now, the town, in its brief, gave a number of reasons. They didn't have a record site to support those, but are you disputing them, or are those reasons the reasons that were given at the hearing?
I don't think those reasons were specifically given, but I don't dispute that those are the reasons that the town based its decision on.
Okay, so if the town had reasons, including that, you know, fire trucks have been able to get down the roads to respond to fires, there haven't been any accidents, people have been able to, you know, even though you have to back up, one person might have to back up to pass, they end up doing it, that there really haven't been any problems, then why, you know, how do you prevail in appealing that, even if you do have standing? Because why doesn't that satisfy what the statute says, which is that the road just needs to be reasonably safe and convenient for travelers?
Well, Your Honor, with respect to, and this maybe holds more true with Round Cove Road, which is the town way, but the town, when it took the road, actually set out a standard for its construction. Said it had to be 20 feet wide and up to county road standards. Furthermore, the town, in setting sort of minimum standards for roads that are to be taken by town. In other words, when private roads become taken by the town, they have a bylaw that provides that roads have to be 20 foot wide and of a suitable grading material to a depth of 6 inches. Round Cove Road, and you can see the pictures in the record appendix, is only 10 feet wide, and it's deeply rutted, and it's over a period, over a distance of about 900 feet, in contradistinction to the entirety of Round Cove Road, which is largely paved up to that point. So,
what's your best case for the legal authority for the proposition that the road needed to be upgraded or widened and paved over by the town?
well, I think the central case here is the Sturdy case that upon which the Superior Court judge relied, both with respect to standing and a discussion of the town's discretion under Section 1 of Chapter 84. It's not really on point. I know of no other case dealing with this specifically, but
is there a passage in Sturdy that you thought helped you? Because I mean, I read it, it came out against the position you're taking here.
well, Sturdy is an interesting case because it rules first that an abutter has no standing. So to that extent, anything beyond that probably is dictum. But in that case, the court noted that mandamus would not be at issue here because there were no standards set by which a court could set forth an order of mandamus. That's different in this case. So I'm not saying Sturdy is controlling on that point. It's just instructive on that point.
So your argument is that because they have the 20-foot wide requirement and the paving requirement, 6-inch, whatever, pavement layer requirement, that those are concrete standards such that mandamus, the concerns in Sturdy are not present here, that they're concrete requirements that would support a mandamus.
That's correct, Your Honor. That would set sort of a minimum standard. If there are no other further questions, I will submit on brief.
Seeing none, thank you. Ms. Ecker.
May it please the court, Deborah Ecker for the town of Harwich. As your honors are aware, there are two roads here. One is Seth Whitfield, which is a county road, and then the other is Round Cove Road, which is a town road. My brother relies on two statutes, Chapter 82, which goes to the county road, and then Chapter 84, which goes to the town road. It's the town's argument that neither provide plaintiff with a private cause of action. First, I'll start with Seth Whitfield, which is the county road. It's undisputed in the record that Barnstable County was never dissolved. So it remains a county road. The town doesn't have responsibility for that road, but that statute also doesn't provide a private cause of action. What it does have is Section 17, which allows a city or a town to exercise original jurisdiction concurrent with the county commissioners and to have an applicant petition the town for, in this case, to widen and pave. That petition was made by Mr. FRATUS. It is a discretionary function, but there is nothing in there that provides Mr. FRATUS with standing then to bring a private cause of action to have this court order that the town widen, repair, maintain a county road.
All right, so you would acknowledge that Mr. FRATUS has a right to petition, but he doesn't have a right to sue.
Correct.
The distinction you're drawing, okay.
That is the distinction I'm drawing, and that's what it sets forth in Section 17. And the selectmen heard that. In hindsight, yes, it would have been better to attach the meeting minutes to the record appendix, but in summary judgment, the facts were not in dispute, and that's what's referred to in the record appendix. So that's Seth Whitfield Road.
Wait, before you leave Seth Whitfield Road, Chapter 84, Section 1 says, highways and townways shall be kept in repair at the expense of the town. And Judge Wolohojian went on to read the things about petitioning the state, but doesn't that give the town responsibility for highways located in the town?
Not as I read it. Well, not as I read it. I guess it depends how you define a highway in the town. And if you're defining it as a county road, perhaps they have some obligation to repair, but they then have to petition with the commission. So the better course of action would be to petition the county to repair Seth Whitfield Road. But it also says that so that they may be kept in a reasonably safe and convenient manner for travelers. And so again, may is not shall, it is discretionary on the part of the town.
Well, I think there it's used in a different way, the where may. I mean, it's that the obligation to maintain those roads is mandatory. It says shall. And I think the way that may is used later is rather permissive, so that to enable the roads to be kept in reasonably safe and convenient for travelers. It doesn't diminish the word shall that appears earlier. Do you see what I'm saying?
I do understand what you're saying.
Townways shall be maintained in a way that that they may be reasonably safe and convenient for travelers. So I don't think it makes the obligation permissive. The obligation to repair is still mandatory. It's just that that there's a lot of discretion, it seems to me, built into what that standard is.
Yeah, I was just looking at the other sections. While that may be correct, for purposes of standing, I don't think it provides a private cause of action. That would be between the town and the county as to what gets repaired and when it's repaired, and then who then pays for the repair. And so While that may be, I think it would be a conversation with the county and not a private cause of action.
So the town did hear Mr. Freitas's petition and denied it, and we don't have that the record of that. What's the standard they apply when they're considering something like that?
Whether it's reasonably safe for travel. So what they did look at, and which was undisputed on a summary judgment, is there haven't been any incidents on that road. There have been the ability of the fire trucks to go up and down when there have been incidents. So it hasn't been an issue. In fact, there was no record of any accidents on that road. So they had their experts, the highway, the fire, look at it and decide it was reasonably safe for travel. It is a dead-end road that goes to a state park. And so it has been navigated in the past with no difficulty.
So if Mr. Freitas wants to get the road improved, is it impossible?
He could petition the county, but the county then would also have discretion to say that it doesn't need to be improved. Abutters and travelers don't have the obligation or don't have the standing to order that towns or counties for that matter repair roads.
And
I'm sorry.
He couldn't do it himself.
To repair it, he would have to petition. So for when you apply for a special permit, for instance, when he subdivided the property, I haven't looked at the permit, but presumably the permit required that the road be widened and paved. That is one way to do it. He could petition, presumably the town, to say, okay, you're not going to do it. Can I do it? And get some type of permit that way. But you'd have to get permission from the county and or the town because they're the owners of the property. Right, so that leads me, there is Round Cove Road, which is covered under Chapter 84. And that does not provide a private cause of action to individuals either unless you are injured. And that is Section 15. And then again, the award, if you are injured, is capped at $5,000. There's nothing that provides a group of individuals or an abutter or traveler as a private cause of action. Sturdy does not assist plaintiffs in their argument. In fact, after the quote that my brother cites in his brief, there is a specific statement that states these specific remedies afforded by statute suggest that an additional private remedy for abutters is not implied in the statute. In that case, my understanding is the parties assumed that the abutters could have a private right of action. And so the court in the decision suggests that there is no such private remedy for that.
Attorney Ecker, you, I was just checking the joint statement of undisputed facts. And I didn't see in there, but I may just be missing it, looking at it quickly now, any reference to the town's basis of decision. I mean, you've told us that it was undisputed what the town's reasoning was, but I didn't see anything in there. Was it somewhere else?
It was not, Your Honor. It's not in the record, no. It is not in the record, and in hindsight, that would have been better, but my understanding.
Yeah, I mean, because I saw the reasoning, you put it in your brief at page, I don't know, maybe 37 or something. And I immediately I looked for a site, and then to go look for it, I was looking for this because it would seem to me important to have the town's reasoning.
Well, for the town's argument, it really would not be, because one, we say there's no standing and there's no private right of action to be able to bring a case under either Chapter 82 or Chapter 84. He was, afforded a petition and that was denied, but it doesn't provide him with a private cause of action in court. But yes, it's not in the record appendix.
Okay, thank you.
If there are no further questions, Your Honor, I would rely on our brief and ask that the lower court's decision be affirmed.
Seeing none, I thank you. Thank you both. We'll take this under advisement.
Thank you, Your Honors.
Thank you, Your Honor.
We are live and on the record.
Thank you. Welcome to the appeals court. I'm Justice Meade. With me this morning are Justice Wolohojian and Justice Massing. Will be your panel. Each side gets 15 minutes. You needn't use all of your time. We've read everything and we don't entertain rebuttal. With that, I'll call this case 2020P 653 ADH Collision of Boston versus Vigorito and another. Mr. Parks.
Good morning. May it please the court, this is William C. Parks representing Rocco Vigorito and Anna Maria Vigorito as trustees of A&R Trust, and Rocco Vigorito individually, who are the appellants. We are appealing the trial court's award of multiple damages under 93A and attorney's fees under 93A, under business 93A. After a jury trial below, the jury found that 93A had been violated and the violation was willful and knowing, but there were no damages, making a $0 damages award. The jury also found $66,000 of contract damages. After that, in a post-trial proceeding—
Would you agree, Mr. Parks, that that the jury, I mean, I think we could say that the jury awarded no separate damages for 93A?
That is one way that it could be characterized. However, the jury—
The judge understood it that way, right?
That's
Because
correct,
the
but she
judge—
was—
We've got the judge's instructions, we've got the special verdict form, and that understanding is permissible, taking all of those things into account.
We disagree with that. We don't think that. So the judge made a finding that the contract damages arose out of the same conduct and were not a freestanding, unrelated cause of action that happened to be tried with the 93A claim. That's in the order attached to our brief at page 5758. And that's what we're saying was an error. The judge should not have doubled those contract damages and awarded the plaintiff attorney fees and costs because they did not arise out of the same conduct. And in fact, freestanding unrelated cause of action is not the proper test under 93A. So under business 93A, there have to be—
No, but I was just asking you actually, because you started off with telling us what the jury did.
Yes.
And there's no doubt that the jury put 0 as damages on the 93A claim. But why is it that can't, given the way the jury were instructed, why is it that can't be understood where they were, you could read it to mean that the jury was simply told they can't duplicate damages. So in other words, they can't put down 66,000 for the contract and then 66,000 for 93A if you know, they can't duplicate the same number over and over again. Why is it, given that they were instructed that way, that when they put 0, it necessarily means, as you're arguing, that they found that there was no damage attached to any 93A conduct?
Well, because of the way that the jury slip was instructed. So question number 2 of the verdict slip asked the jury, what amount of money do you award as damages for breach or breaches of the lease? And then it says, in answering this question, do not include any damages that you intend to award the tenant for any other question. So they were told that they should not, they should not simply put damages from, they shouldn't duplicate the damages or, put them into another claim. They were instructed as to business losses regarding the 93A requirement that there be actual business losses as distinct from breach of contract losses. So there were instructions that were distinct about both of those issues.
Mr. Parks, isn't the 66,000 the exact amount of unpaid utilities and cost of snow removal?
Well, according to the evidence, we believe that it is, and we believe that the plaintiff conceded that that is the case at the post-trial motion.
And a follow-up, and it includes, the contract claim includes conduct that occurred at least 2 years before Wynn became involved at all.
Yes, and really that is one very important point, because in order for there to be a causal connection between 93A conduct and damages, we would say that they would have to be closer in time than that. The fact is, and this is not disputed, is that the utility bills dated from the very start of the lease, whereas the 93A claims and the demand letters didn't come. So the start of the lease in sometime in 2014, but the demand letter, the 93A demand letter, came in 2016. So we don't think that there was this causal connection here, that this had been the practice of the parties from the very start of the lease to have the tenant be paying the utilities. And that was never an issue. The relationship between them was perfectly fine, according to the plaintiff, until there was a third party offer to purchase the property. And so it's in the T-Butera case, which is more of a more traditional example of what happened, how this can happen. There was a breach of contract that was also found to be a breach of 93A, and the jury was asked that it was the same transaction or occurrence, but it was very straightforward in time. The timeline goes linearly forward. The parties had a relationship, a contractual relationship. There was a breach, and that breach also violated 93A. I think the Twin Fires case that's cited by the plaintiff is similar in that way, that there is a relationship between the parties, there is a fraudulent misrepresentation, and that relationship, that misrepresentation also violated 93A. So there's kind of a forward in time concept here. We haven't seen any cases where what happened, which is what happened here, where the relationship between the parties was fine, and then there was arguably a violation of 93A, and then it caused the parties to re-examine their contractual relationship and then reach back in time and say, hey, we think there was another violation that also happened starting a couple of years ago of the contract, that later that became a 93A violation. They're simply not the same thing. And we talked a little bit in our brief about a different area of law, talking about mandatory or permissive counterclaims, where we think it's similar language with a similar purpose. The purpose of 93A and having demand letters is to encourage settlement, and the purpose of mandatory counterclaims is to minimize litigation, so that it's all things that are conceptually related or put together. And there are two tests, and we think both of them are not met here. The first test is a logical relationship. And I think I've talked a little bit about that, how that it doesn't make sense that if there are violations of 93A beginning in 2016, that their breaches of contract reaching back to 2014 would be logically connected in such a way that it'd be equivalent to a mandatory
during the trial. Yes. What was so we know that the jury found that there was a 93A violation.
Yes.
During the trial, what was the plaintiff's argument as to what constituted the Chapter 93A violations?
I'm going to have to pull up the record for a moment, if you'll just bear with me. I have the transcripts. Just a moment.
Well, I mean, I don't want to take up your time, but why is it that having found a willful violation of 93A, that finding would not support an award of attorney's fees, setting aside the amount of the fees for the moment, in the abstract, an award of attorney's fees.
Certainly, Your Honor. So in the business context, there have to be actual damages or prospective damages for there to be an award of attorney's fees. It's not so in Consumer 93A, which is a different statute, which is Section 9 of the statute, there are statutory damages of $25. So simply proving a violation of 93A under Consumer 93A is enough to establish, to support an award of attorney's fees and multiple damages. It's possible for the $25 to be trebled or doubled and then there to be an attorney's fees award. In the business context, that's not true. And there's a case that's very similar to this one, minus the contract damages, which is called Halper v. Demeter that we cite in our brief, where a landlord engaged in some conduct that violated 93A that bothered a tenant and was irritating to them or something of that nature, but didn't actually have any business losses, so that an attorney's fees award in that context was not appropriate. Business 93A just requires something more than a mere violation.
So that's why you argue also, that's why you argue that there wasn't an injunction, there was a stipulation, because an injunction would also warrant an award under 93A, right?
Yeah, if the injunction was to remedy prospective damages, if you look at the section 11 of the statute, I believe it's the second paragraph that says that you can show that there are, if you have not suffered any loss of property, money or property, may obtain an injunction if it can be shown that the aforementioned unfair method of competition, act or practice, may have the effect of causing such loss of money or property. So if you were to make that showing and the court awarded an injunction to prevent the loss of money or property, then yes, that would be possible. I think the plaintiff's argument is yes.
Mr. Parks, I'm sorry to interrupt, but what about the language in section 11 that says attorney's fees may be awarded irrespective of the amount in controversy?
So yeah, we seem like the plaintiff is relying on that kind of heavily, that because I guess it's because their fees are disproportionate to the amount of damages. But what we don't think, we haven't found a case where it was sufficient that if there were no 93A damages, the proportionality part of the statute would come into effect. The difference between $0 in damages and $1 of damages is very significant in this context. You have to read all of section 11 as a whole. It isn't really about proportionality. It's about whether the plaintiff has damages. And what we're arguing is that because these contract damages weren't from the same underlying transaction or occurrence, they weren't causally connected to the 93A violations, it was inappropriate for them to be multiplied, and they shouldn't support an award of attorney's fees and cost.
Why wouldn't it be in furtherance of public policy for the legislature to choose to award attorney's fees to correct commercial wrongs that violate 93A, irrespective of the amount in controversy?
I think it certainly would be good public policy to discourage unfair or deceptive acts or practices. But what the legislature didn't do was say, if they put in a requirement right at the first line or two of section 11 that someone has to have suffered a loss of money or property, real or personal. We're talking about the business context here.
What if the money here is the cost of bringing a suit to stop the conduct, which is what was argued during the plaintiff's closing, that and I think that was one of the themes of their trial was that we had to sue in order to stop the landlord's course of conduct.
They make that argument, but they did not, they sought a preliminary injunction and there was a stipulation, but ultimately what they really asked for was merely a declaratory judgment that they were not in breach of the lease in order to, and that would have been sufficient, I think, to prevent them from being evicted. They didn't, it wasn't as if the landlord brought this case and it was an eviction case that they had to defend. It's not fair for them to argue that they were forced to do this to stop the landlord's conduct.
I want to just follow up on my question about the injunction. So the plaintiffs sought an injunction. I think it was to get your client to stop putting snow back on their premises or something like that, and it was disposed of by stipulation. So your client agreed to do what they asked. Wasn't that the equivalent of getting an injunction?
It wasn't the equivalent to a finding that there was going to be a loss of money or property unless the stipulation was entered into. It wasn't necessarily an injunction that met the standards of 93A. I agree that the stipulation was, and says on its face that it was intended to have the force and effect of an injunction. I don't think anyone can argue otherwise now, but it's not necessarily, that my client agreed that if the parties didn't enter into this stipulation, that anyone would suffer economic loss. And the jury so found. They did not find economic loss due to the 93A.
Mr. Parks, what's our standard of review on the issue of causal connection? Is it a question of law or fact?
So I believe that it is both a de novo review and also a clear error standard. And I say that because if you look at the judge's order that awarding the attorney's fees, she talks about how this contract claim was not a freestanding, unrelated cause of action that happened to be tried with the 93A claim or words to that effect. And that's not the correct test. It's really causal connection. So in that sense, the judge applied the wrong test and it's de novo review. There are other citations in her order, however. She does cite the correct case and even quotes from it, Cohen, with the causal connection. And I think that our argument under that standard, whether it's the same or underlying transaction or occurrence, that is reviewed according to the clear error standard because it's an application of law to the facts.
Okay, thank you very much. Mr. Gordon.
Thank you, Your Honor. May it please the court, my name is Stephen Gordon. I represent the appellee plaintiff below ADH Collision. It is obvious that the panel is very familiar with the record and the arguments of counsel in the briefs. I would therefore like to address my time to the questions that the panel has raised during the appellant's argument. Justice Wolohojian asked about the jury verdict slip, the special verdict, the zero damages for 93A. There are two issues for appellee with respect to that. Later on in the argument, Justice Wolohojian also noted that the real cost, the real damage to ADH Collision was the hundreds of thousands of dollars of legal fees incurred in maintaining its lease. Now, the trial judge did two things with respect to
But Ms. Attorney Gordon, was that argued to the judge below? Because not, that wasn't, or to the jury, that a component of the 93A damages were the attorney's fees?
It was not argued to the jury, Your Honor, because the trial judge made it clear, and it is in the record, made it clear that she was reserving the issue of attorney's fees in every respect to
Right, I understand that. That wasn't my question. To the extent that you're looking, you're trying to characterize attorney's fees as damages, as opposed to just attorney's fees, but as the damages for the 93A claim. That was not argued down below, correct?
That is correct, Your Honor. We did bring a cross appeal on that issue, and we withdrew our cross appeal. Our view is that we have a breach of there is only one transaction here, and that is a lease. Everything in this case arises from that lease. We have claims for breach of contract. We have a claim for declaratory judgment that the tenant is not in breach of the lease, which was crucial, obviously, to preserving the appellee's business. And we have the 93A claim. All the same transaction, all arising from the same lease. Now,
Mr. Gordon,
Yes.
in the verdict slip, and when it says not to include any damage you intend to award the tenant in any other question, and they award the 66 on the breach, and then they come up with 0 on the 93A. How can we look at that and decide that they're connected when the jury flat out said they're not connected?
Your Honor, I do not believe that the jury said that they were not connected. The judge instructed not to duplicate damages, and the jury did not duplicate damages. Now that gets me to a question that you, Justice Meade, asked during the appellant's argument, and that is, isn't $66,000 the exact amount of the utility and snow removal? It's actually something less than that. And what I would say is what the appellant wants is for the panel to make a conjecture with respect to what exactly was in the jury's mind when they put that number down. Now, if you look at the complaint, again, the breach of contract count in the complaint, paragraph 26, it claims a breach of the covenant of quiet enjoyment, and paragraph 27 claims a breach of the obligation to pay for utilities and provide snow removal. It's very difficult to imagine or determine, I should say, damages for breach of the covenant of quiet enjoyment. None of us will know, none of us will ever know. Trial lawyers always spend sleepless nights trying to figure out what was in the jury's mind. But we're not in the jury.
Let me, rather than speculating, we do know that some of the conduct that was alleged to resulted in the breach occurred years before the Wynn people had any interest in the property.
That is
correct. Back to
correct.
2014, and Wynn's not in the picture until 2016. Is that correct?
That is absolutely correct, Your Honor. But the breach of contract count is one for quiet enjoyment, and the appellee tenant had quiet enjoyment from November of 2014 until the summer of 2016, post Wynn's multi-million-dollar offers, and the quiet enjoyment ended in the summer of 2016, and that's what we brought suit for, to determine that the tenant was not in breach of the lease, to enforce the landlord's obligations under the lease. That was the 93A conduct that was complained of, and that was most of the testimony at the trial. Again, a question from Justice Wolohojian. That was most of the testimony in the trial was with respect to the breach of the covenant of quiet enjoyment. The tenant had no quiet enjoyment from the time of Wynn's appearance on the scene through the trial.
Did the tenant have quiet enjoyment between 2014 and 2016?
Yes. Yes, Your Honor, the tenant did have quiet enjoyment. The breach, obviously the tenant was not bringing any lawsuits during that period of time, was not sending any letters. In fact, the the whole case began with a letter from the landlord, not a letter from the tenant. The whole case began with a letter from the landlord alleging 2 pages of technical breaches that had never been raised by the landlord before. So the breach of contract, and again, the jury's damages are unspecified as to the reason for them. Was it? I mean, they didn't see the complaint, but was it for breach of quiet enjoyment? Was it for non-payment of utilities? That's pure conjecture. There may be a logical connection. Maybe that's what they used. Maybe. But the fact of the matter is that based upon the exact same underlying transaction, the lease, the jury awarded damages and found a violation of 93A and found that the violation was willful and knowing, and did so in a context where they were prohibited by the judge from considering the cost of getting there.
What are we to make, Mr. Gordon, of the fact that having found the Section 11 violation, that the jury awarded no damages?
Because they had already, two things I think Your Honor should make from that. First of all, they had already awarded what they felt were for whatever reason, they felt were the amount of the money damages, and they were admonished not to duplicate or repeat those damages. Secondly, what the jury was saying is the cost of the major cost, obviously, of the willful and knowing violation of 93A, they were specifically told not to consider that cost. The judge said that she will do that, which in fact she did do. And moving on to other questions,
could you repeat that again? What did the judge say on that? They shouldn't consider what?
They should not consider attorney's fees.
Just attorney's fees. Okay. So I know we can't necessarily find this from the jury's findings, but suppose the jury found, yes, there was a willful violation of 93A. However, these are both sophisticated parties, and the monetary damage that was caused to your client by this unfair practice was actually zero, like they wrote down. So yes, there was a violation, but they didn't suffer any damages from it. Would you be entitled? Would that give you an entitlement to doubling of damages and attorney's fees?
I would say yes, Your Honor. First of all, because it's part of the same underlying transaction. Secondly, there is additional other relief that the plaintiff in this case received. I would certainly not want to be distinguishing between a stipulation in lieu of injunction and an actual injunction entered by the court, because that will just disappear, stipulations in lieu of injunction, if they don't have the same effect. And that was in appellant's brief. They said, well, an injunction is to preserve the status quo. No, that injunction did not preserve the status quo. The status quo was frankly intolerable. And that's why the plaintiff appellee here obtained an injunction to stop the outrageous behavior of the appellant landlord. So that was a second form of relief. And the third, of course, is the main event, the declaratory judgment. And the jury did find that the tenant was not in breach of the lease, which was crucial to maintaining ADH Collision's business. It has only one location. And if it loses that location, it has no business, it's finished. So I think, Your Honor, that there is the monetary damages for the same underlying transaction. We can suppose what the jury had in its minds, its collective minds, with respect to the $66,000, but the breach of contract claimed was quiet enjoyment and non-payment of utilities. They came up with a dollar amount. We can have conjecture as to what that meant, but they did not specify what it meant. And they were admonished not to duplicate damages. They were admonished not to consider attorney's fees, and they came back with the verdict that they did come back with. And with respect to the connection between the two, appellant has focused only on the freestanding unrelated cause of action. Even if the jury specifically stated, which of course they did not, that the $66,000 was for utilities, that is not a freestanding transaction. That is the same, arising out of the same exact transaction, this one lease. But there were two other reasons why the trial judge said that she was finding the connection sufficient to award 93A attorney's fees. The first was that the special verdict form directed the jury in a manner that did not preclude the trial judge from finding the damages found by the jury to be the result of the landlord's breach of contract. And the second thing, of course, is this contract claim was hardly a freestanding unrelated cause of action. And the third thing, and we cite this as most important in our brief, the trial court found the causal connection existed, and I quote from her decision, based on the jury's verdict and the evidence at trial. So I think there's no question that what the plaintiff received here was an award for breach of contract, a lease, a judicial determination that the lease was still valid, a declaratory judgment based on a jury's verdict that the tenant had not breached the lease, and injunctive relief, not to preserve the status quo, but to address outrageous conduct. We actually had and presented to the jury and to the judge, of course, a video of Mr. Vigorito plowing the snow from the street onto ADH's premises after ADH had paid for the snow removal earlier in the morning. So it was based on that video evidence, irrefutable video evidence. Mr. Vigorito never denied that it was his truck and he was plowing the snow. He said, well, I was trying to be helpful, but the video evidence was indisputable that he was plowing snow right up against the doorways of ADH Collision. That's why we got an injunction, and that's part of the willful and knowing unfair or deceptive trade practices committed by the landlord in this case. So, unless there are other questions from the panel, that would conclude the appellee's argument, and I thank you very much, Your Honor, for your attention.
Thank you. Thank you both. We'll take this under advisement.
Thank you, Your Honors.
Partially impounded action.
We are live and on the record.
Thank you. Welcome to the appeals court. My name is Justice Meade. With me this morning are Justice Wolohojian and Justice Massing will be the panel for this case. And that is 2020 P785 SM versus NW. Mr. Nyman.
Good morning. May it please the court. My name is Steve Nyman. I represent the defendant in this matter. I represented the defendant down below in the Somerville District Court, and there's one issue before the court that has some subparts that I'd like to discuss with the court this morning. First and foremost, it's the contention of the defendant that there were not 3 or more willful acts of malicious conduct aimed at a specific person, in this case the plaintiff, with the intent to cause fear, intimidation, abuse, damage to property, and that does in fact cause fear, abuse, or damage to property. First of all, any reference to fear is fleeting at best, both in the affidavit and in the testimony during the course of the hearing. The fear that the plaintiff had, if any, is actually fear of the defendant's husband, who was not a party to this action. There was a separate 209A that was brought against him.
There's evidence, though, there's testimony by the plaintiff that the defendant and her husband were acting as a team. So,
Right.
So if that's taking that testimony as it came in, why isn't that enough to permit the judge to attach the conduct of the husband to the defendant?
Well, there's no
or
evidence.
to at least to consider it.
Well, she did consider it, but there's no evidence of it. It's a conclusory statement that is not based on anything.
Well, it's testimony under oath, so that is evidence.
Right, but it's not based on anything in fact, and there's nothing supporting the statement that was made by the plaintiff, that this was in fact the case. As a matter of fact, there's no indication that the defendant was around at the time that these threats were made. There's really no time attribution to it as well. If you take a look at the affidavit, it says on or about January 1st, 2019. Well, this doesn't come about until March 12th of 2020. So even if you were to take it at face value, there's such a gap in the time frame here that it doesn't really make sense that any fear.
Well, we're talking about that. I understand you're talking about the affidavit, but I'm talking about the testimony that's reflected in the hearing transcript. It's not limited. It's not limited to what's in the affidavit.
Right, and I understand what the court's saying, but well, of course, if you get there, then nothing should have issued in the first place. But I understand what the court's saying, but there really, if you read everything, and I'm sure the court did, that the plaintiff said he's not afraid of the defendant. He wants her out of the house, and his point is now that there's criminal charges against her husband, she has nothing to lose. And therefore, maybe she'll do something to him. That's really how this reads. And there's no indication that they had any real problems before this. I mean, reading everything they said, she stomped, she huffed, she puffed, she snarled in his face, I mean, and then destroyed his food. I mean, I don't, first of all, understand any of those to be predicates to the three acts. I'm not sure what the huffing and puffing is. And more telling is his statements that for the most part, the defendant ignored him. They had minimal contact. She outright ignored him. He thinks that she doesn't want to be near him either. It just doesn't make a lot of sense here. I understand.
Well, I mean, I have a couple of questions, if I may. If I look at the affidavit, there's handwriting. We don't have a transcript of the very first ex parte hearing, correct?
Correct.
So, but at the bottom of the affidavit, so I'm looking at appendix page, I think it's 4. There's some handwriting that it sort of has arrows. See that?
Yeah.
I understood that to be the judge's handwriting, sort of notes. Do you, based on what was said at the hearing, and the way that I get there is that at the beginning of the hearing transcript, we do have, when the judge recites what the testimony was at the previous hearing, it corresponds pretty much verbatim to these notes.
Well, that's really interesting. That's the first that ever crossed my mind. My assumption was, I know that he was represented by counsel, and my assumption was when he filled this out that his attorney added this on, fearing that what was above that, and I guess we're speculating here, but fearing that everything was insignificant.
Well, I don't know that my understanding is correct or any better than yours. But I did note that at the beginning of the hearing, on page 15 of the record appendix, the judge read into the record what it was that the judge recalled of the testimony the previous time, and it actually corresponds to what's at the bottom of the affidavit.
Right, and right, it does. I had just assumed something different. I assumed that she was, first of all, reading verbatim what you could clearly read from the affidavit, and then summarizing, which is a little bit more complicated, the last two sentences with the arrows that the court's referring to.
Right, but the judge does say when Mr., I won't use the name, came before the court on March 12th of 2020, he also indicated and then read those notes. So, well, whether or not it was by way of affidavit or by way of the testimony, that was the information that the judge understood was before the judge the first time.
Correct.
Right. And
right.
that information could also be considered by the judge on the extent in issuing the extension order.
That's certainly correct.
Yeah. So we have not just huffing and puffing and stomping, but it says that that she acts irate when he's around, that her boyfriend, but I suppose is now husband, threatened to murder him on her behalf, destruction of his food and other things, and that she'd yelled at him at things being in his way. So later on, the testimony by the plaintiff is that the death threats had been made on multiple occasions, 3 or 4. If those can be considered in with respect to your client, why isn't the testimony that there were that death threats were made on 3 or 4 occasions? Why wouldn't that be enough to satisfy the requirement of 3 acts?
I don't know how they're attributed to my client, so I hope I'm answering the question correctly.
That's why I said if they can be attributed, sufficiently tied to your client, why isn't the testimony that there were 3 or 4 occurrences of that enough to satisfy just numerosity?
I actually didn't see where there were 3 or 4 occurrences. I don't. Can you just tell me the page the court's referring to?
Sure. On page 20, so basic record appendix page 20, okay. Transcript page 11. So basically, name contends that he would murder blank. He said that at least 2 times to my face, if not 3 or 4. And he was also showing you a knife. Yes, showing me a knife. The next page says that death threats were extremely, in the plural, were extremely clearly worded. He stated at least 2 times, if not 3 or 4. And there's, testimony later on that as a result of the death threats, the plaintiff had moved out of the premises. So I'm asking, why wouldn't that be enough to satisfy the number?
So I think I understand what the court is looking at now. I view that as one incident. So if you're looking at the bottom of page 20, he said it at least 2 times to my face, if not 3 or 4, and he was showing you a knife in the sheath at that time. Yes, that's all one incident, Your Honor, I think that they're talking about right there. And that was the threats that prompted the police to come and the initiation of the criminal complaint against Mr. Campolito, who's not a party to the action before this court.
Okay, so
that's just one incident, though.
You take it's just multiple threats during one incident.
Right, and that's all it is. There's no indication that this happened anywhere else or was a discussion anywhere else. relative to Mr. Campolito and the plaintiff, relative to the defendant. Right. The defendant, he mentions those other things about the food, about snarling, which clearly, you know, in my estimation, don't amount to those predicate acts. They just don't. These are just, you know, arguments or issues of discomfort in a household.
Do they live in the same apartment? Are they roommates? Are they in the, what's the situation here?
It's a house that they all rented together. So, and Mr. Campolito was actually the first person to have the lease there. When he got married, his wife came in. The plaintiff had come in at one time. There are other roommates that had come in. Mr. Campolito had got the initial lease with a bunch of friends from college. And as each of them had changes in his life, they moved out. And you were left with a group of, I think, 5 at the time this happened. It's a pretty simple one-issue matter. I don't know that the court has further questions. I'm certainly happy to address any of them. I think all this stuff has really been covered. I keep getting back to the insufficiency of the predicate to issue this in the first place or at all. And I would just emphasize that once again for the court and focus on the underlying reason that it appears pretty clear that the plaintiff wants the wife out because he has this issue with the husband. But all the things he says throughout the course of his testimony and his affidavit relative to the defendant are relatively minor and don't amount to that willful and malicious conduct that's necessary to issue this order.
Okay, thank you, Mr. Nyman. We'll take this under advisement.
Okay, thank you very much.